Hey Charleston, Jim Smoak here, your local real estate agent and martial arts geek. Welcome to this week's 2 Tips for Tuesday, where I dish out advice on both real estate and personal safety topics. This week's real estate tip is about whether title insurance for the homeowner is worth it, and the safety tip is about the importance of understanding the law around self-defense. So let's dig in. One of the posts I put on my site this week was based on an article about title insurance. It's linked below for you to read. If you purchase a house by taking out a mortgage, which most of us do, your lender will probably require you to purchase a title insurance policy. However, what many people don't know is that this policy is limited to protecting the mortgage company in case of a title issue, not you. So what title issues could there be? Lenders do a title search before they issue the loan, but it's not uncommon for title issues to surface after the loan is issued because of limited or faulty title management processes. Things like back taxes or liens placed on the title by contractors can surface. These groups would probably prefer to go after the lender because they have deeper pockets, but lenders are almost always protected by the insurance policy they have you pay for. So what can you do? Well, you could do the same thing by taking out a title insurance policy that protects you. Here's the kicker. Because the title insurance company has already expended the effort on the title search to issue the lender's policy, they'll usually offer you a substantially discounted rate for you to purchase a policy at the time of closing that covers you. Like other types of insurance, title insurance is all about mitigating risk, and it's a worthwhile thing to think about as a title claim can be really expensive. This takes us to our personal safety tip of the week, which is also about understanding risk, or more specifically, it's about the importance of understanding local laws regarding what you can and can't do to physically defend yourself. Here are a few things to consider when it comes to the legal implications of self-defense. First, if you cause the escalation of the situation, a claim of self-defense may not get you far. As an example, if you antagonized a person to a degree that resulted in them reacting physically, you may be held responsible for any damage you caused in the interaction. The law will consider whether you feared that you would be seriously hurt or worse, and whether that fear was reasonable in the eyes of the law. Your local law may require you to look for a practical way of avoiding the danger, such as simply walking away. South Carolina is a castle doctrine state, and the state has implemented this law in a specific way. In basic terms, this law considers your home as your castle and doesn't place a duty on you to retreat when confronted by an attacking trespasser in your home. However, there are limitations to this law, such as people on your property but not actually in your house. Could castle doctrine cover that? Well, maybe, but maybe not in your area. The overall point is to do your research and know the law so you know the legal requirements based on the situation. After all, knowledge is power. That's it for this week's 2 Tips for Tuesdays. Hey, you have your choice of realtors, so thank you for the privilege of your time. If you like this video, do me a favor. Share it, like it, and subscribe to my page. Until next week, I wish you happy home ownership, and don't forget about getting educated on local self-defense law. Be well.